Good morning, this is your Kelso Report for Wednesday, May 2nd. I'm your host, Clark Kelso. Today we have a cert grant and a habeas case, cases involving telecommunications, identity theft, contract awards, asbestos exposure, and criminal procedure. So it's an interesting group of cases. We begin with a cert grant and a habeas case. In Padilla versus Kentucky, the Supreme Court in 2010 held that criminal defendants receive ineffective assistance of counsel under the Sixth Amendment when their attorneys fail to advise them that pleading guilty to an offense will subject them to deportation. Well, the court now has granted cert in Chaidez versus United States to decide whether Padilla applies to persons whose convictions became final before Padilla was announced. So it's a retroactivity decision for the court. Next, we turn to the California Court of Appeal for the rest of our cases. The first, a consumer protection case involving telecommunications. A consumer had filed a class action against defendant Pacific Bell Telephone Company and its billing contractor for their inclusion of allegedly unauthorized charges on a subscriber's telephone bill, a practice known as cramming, which violates Public Utilities Code Section 2890, Subdivision A. The Superior Court sustained defendant's demurrer without leave to amend on the ground that the Public Utilities Commission had primary or exclusive jurisdiction over the dispute. The First District disagreed. Section 1759A provides that no court except the Supreme Court or a Court of Appeal has jurisdiction to interfere with the PUC's performance of its official duties. But Section 2106 allows an action to be filed in the Superior Court for damages caused by an allegedly unlawful act of a public utility. The First District held that a claim for damages for cramming in violation of Section 2890 falls on the 2106 line of the jurisdiction because it's an action for damages caused by an allegedly unlawful act of a public utility. And the public utility has taken no steps to enforce 2890. Accordingly, the First District reversed and remanded the case for further proceedings in the Superior Court. The plaintiff's going to get a chance to prove his damages claim. Next, we have a criminal law case involving Asperger's syndrome. The defendant in People v. Larson was charged and convicted of conspiracy to commit murder and solicitation to commit murder. Both conspiracy and solicitation, of course, require proof of the element that the defendant had the specific intent to commit or effectuate commission of the alleged underlying offense, in this case, murder. The defense put on evidence from an expert that the defendant had Asperger's syndrome, and the expert also described the defendant's disorder to include features pertinent to the effort of the defense to negate the intent element of the solicitation and conspiracy charges. Specifically, his lack of social or mental filters, an inclination to make inappropriate comments, an inordinate desire to please others, susceptibility to manipulation, obsessive thinking, and compulsive fascination with fantasy role-playing to the exclusion of reality. The expert specifically testified that the defendant is socially naive, subject to manipulation by others to say things adverse to his own interests. Well, the Court of Appeal found this opinion testimony on the effects of defendant's Asperger's syndrome was both probative and admissible on the issue of whether the defendant actually formed and expressed the requisite intent to procure the murder. Given this evidence, the trial court erred in failing to instruct the jury on mental disorder and intent using Cal Crim number 3428. However, the court ultimately affirmed the convictions, finding that the failure to give the instruction was not prejudicial given the overall record in the case, including the fact that the jury was given proper instructions on the intent elements of solicitation and conspiracy. Next, an interesting identity theft case. The defendant in People versus Valenzuela was convicted and sentenced to 4 years in state prison after a jury found him guilty of 1 count of receiving stolen property and 3 misdemeanor counts of identity theft, pursuant to Section 530.5 of the Penal Code. On appeal, the defendant argued that his possession of the identifying information of 3 people at one time on a single page constitutes a single offense rather than 3 offenses. While acknowledging the existence of case law involving various possession crimes that support the defendant's argument, the Second District nevertheless held that the defendant was properly convicted of 3 counts because the legislative history of Section 530.5 demonstrates that it was intended to be an identity theft crime, not a possession crime. As such, it is the number of victims that is the key factor, not whether the defendant possesses the information about separate victims at the same time. Next, we have an attorney's fee case involving contract awards. A subcontractor on a roadway construction project was sued by the victim of an automobile accident, and the subcontractor filed a cross-complaint against the general contractor for contractual indemnity. It ultimately prevailed in its action for indemnity, and then sought attorney fees under the contract. The Superior Court held that the attorney fees clause was limited to claims involving work or performance under the contract, not a claim for indemnity resulting from a third-party tort suit. The Second District disagreed and reversed, noting that the language of the attorney fees clause contained no such limitation and applied by its terms to, quote, any and all disputes arising under or relating to the terms of the conditions, quote, of the subcontract. Well, that's broad enough to include the indemnity claim. Next, an asbestos case. The plaintiffs in Shields versus Hennessy Industries appealed from judgments on the pleadings in favor of defendant Hennessy Industries, the manufacturer of a brake arcing machine. Each of the plaintiffs alleged the defendant's machine was designed and used exclusively for the purpose of shaping, by a grinding action, brake linings that were manufactured by others but contained asbestos fibers that were dangerously released into the air by the normal action of defendant's machine. Well, the trial court ruled that because the defendant's machine itself was not made with asbestos, and defendant did not itself manufacture or distribute any product made with asbestos, the defendant could not be held responsible. On this one, the First District reversed. Now, the question in this case is whether the California Supreme Court's recent decision in O'Neill versus Crane earlier this year applies. You will recall that Crane held that a product manufacturer generally may not be held strictly liable for harm caused by another manufacturer's product. Well, the First District distinguished Crane because the products in Crane were not specifically designed for use with materials containing asbestos, whereas the very purpose of a brake arcing machine is to shape through grinding brake linings that contain asbestos. It seems to me it is a fair ground for distinguishing Crane. The Supreme Court will now have to decide whether it is the correct ground for distinguishing Crane. Finally, a criminal procedure case. The defendant in People versus Roldan was sentenced to life in prison without parole for carrying out a pair of shootings against rival gang members. He contends he was denied a fair trial because the victim of one of the shootings was deported after the preliminary hearing, and he did not have the opportunity to confront him at trial. The Fourth District disagreed with this contention and reversed the convictions stemming from that particular shooting. The prosecution had the witness in custody for 9 months prior to the preliminary hearing with the concurrence of the federal government, The prosecution knew the federal government planned to deport the witness immediately after the preliminary hearing, but the prosecution did not inform the defense counsel of this likelihood. The witness's testimony was not videotaped, and the prosecution made only a few ultimately futile efforts to secure the witness's attendance at trial. The trial court nevertheless permitted the witness's testimony from the preliminary hearing to be read to the jury, concluding that the witness was unavailable. But the 4th District held that the witness's unavailability was partly attributable to the prosecution's own contributing conduct, and its failure to establish it had done everything reasonably possible to secure the witness's attendance at trial required that the conviction related to that witness be reversed. As the court noted, the Sixth Amendment demands a particularized showing of due diligence, and because the prosecution has the burden of proof when it comes to establishing the unavailability of its witnesses. In this case, the prosecution did not meet that burden. And that's it for today's Kelso Report. Have a great day in the law.